Hi, and welcome to What's the Tea in L&E. I'm Leah, and management side employment attorney with Woods Rogers. And today I have a very special guest, Broderick Dunn from Cook Craig. He is an equity partner there. And now Broderick and I have been good friends for a while. Broderick does some management side employment law, but he's here today because he also represents plaintiffs, applicants, employees, former
employees. And thank you, Leah, so much for having me. It's so good to be here.
Yeah, thank you. Well, Broderick is going to give us the deepest, darkest secrets of what he as a plaintiff's attorney looks for when a potential plaintiff comes into his office in the employment world. What are the things that you look for when you say, you know what, yeah, I might take this person's case?
Well, that's a very, very good question, Leah. First, I want to know, is that employee, are they a current employee or are they a former employee? Now, if they're a former employee, I'm going to approach the case a little differently. Whereas if they're a current employee, then I'm going to be able to help them navigate the termination process.
What? So you're actually involved in advising employees sometimes in getting terminated?
Leah, absolutely. Sometimes if you are a manager and you get a perfectly written email from an employee that says, "Dear Bob, I believe that you have discriminated against me based on my race, based on my gender, in violation of the Virginia Human Rights Act and Title VII." Sometimes a lawyer might have helped them with that email.
That is wild. Interesting. And see, I always thought that you would find termination, people who've already been terminated, find that to be more enticing because there's a wrongful termination aspect, right? Someone's lost their job. That sounds better to a jury. So what type of claim are you setting up or looking for when you're working with someone who's still employed?
Well, right off the top of my head, it's a whistleblower claim.
Oh.
And managers need to watch out for this, because if you have an employee who knows the writing's on the wall, who knows, look, I'm about to lose my job, and they complain about something, they engage in protected activity, you don't need to exhaust your administrative remedies before bringing that claim. And there's some beautiful new laws in Virginia where you can bring a state law claim. And as somebody who represents mostly employees, I want to be in state court 9 times out of 10 because, as you know, what don't we have in state court that we have in federal court?
Summary judgment. Yeah, that's a process that we as defense attorneys use to try to get a case kicked before it goes to a jury. So you like getting in front of a jury, having the jury decide whether or not this whistleblower was treated wrongly. All right, so retaliation, whistleblower claims, those are more attractive, I guess. And
for a current employee.
For a current employee, okay. So do you care at all then about performance? Do you ever really care if an employee is a good performer?
Leah, everybody I represent's a good employee, a good performer.
Smart answer. So really, it may not, as much as we address it, right? It may not be maybe because your clients aren't telling you the truth about whether they're a good employer or good performer.
And it depends. You need to have, if they're a poor employee, you need to have that documented. You need to, but if somebody comes in who's been an employee for 10 years and all of a sudden you're questioning their performance, they've been around for 10 years.
All right, that's good enough. So it gets them in the door. All right, what's one more thing you look for?
Organization. How is this person presenting? Are they coming, if I ask them to come up with a timeline, a written timeline, is it something that I can follow? Is it something that I can take a lot of the events in and use it for a demand letter or use it as the basis for a complaint? And also it helps me think of maybe claims that they didn't know that they had.
Can you give me an example?
Yeah, perfect example, Leah. This was a few years ago, I had a young lady who came in with a textbook sexual harassment claim. She was touched inappropriately at a work function.
Allegedly.
And she had told her boss, and he said, suck it up. It happens. And then she quit, which you never want people to do. And so when she came to me and I'd had her do a timeline, I was looking and I said, well, wait, how were you paid? And she was salaried, but she had no job description. There was no employee handbook. And she was working 70 and 80 hour weeks.
Ooh.
And making $50,000. And so she had a textbook misclassification claim.
Oh no! Oh, that's interesting. So organization by an
Organization.
Yeah,
and see, had she not been organized, I wouldn't have thought of that that question.
Okay. Interesting. Well, thank you, Broderick. This is going to go very far for us in advising our clients and for our clients as well. So
don't advise them too well.
Yeah. Oh, no. See, stick with us. All right. Well, thank you for joining us on What's the Tea. Until next time.
Thank you.